So, to business. My topic is criminal law, and the role criminal law can play in a contemporary liberal democracy. What I want to do is sketch an ideal of criminal law. An ideal, I think, is implicit in our existing legal practice and legal rhetoric. An ideal of law as a law fit for citizens to apply to themselves and to subject themselves to. And that's part one, is getting an ideal picture on the table. Part two will be then to look at the challenges that ideal presents to us as citizens. We'll see that if we're to make the ideal even halfway towards being actual, there are some serious challenges we face, some serious difficulties we face. And I'll talk in part two about some of those challenges and difficulties. I want to start, though, by asking about the criminal law's addressees. Theories often talk about the proper aims and scope and content of criminal law. They talk about how law should be enforced and so on. But there is a prior, even more important question. To whom is the law addressed? And in what terms does the law speak to us? In what voice does the law address us? To see why the question matters, here's a very familiar, very simple picture of criminal law and its voice, which goes back to Bentham and beyond. Law, said Bentham, is orders backed by threats. Law appears to us, law speaks to us in the imperative mode, says Bentham. The law says, don't do that, do this. Imperative mode. With any imperative, it invites the question, if I disobey, what then? Imperatives require some kind of backing by way of sanction. Don't do this or else. The or else gives the imperative its persuasive force. The or else in law is or else you'll be punished. You'll be fined or imprisoned or whatever. So law is imperatives, and imperatives have force only if backed by threats of sanctions. Furthermore, imperatives require someone who issues them. Orders, commands require a commander, one who orders. For Bentham, there's a sovereign. The sovereign issues law by way of commands, imperatives, addressed to us as subjects. So for Bentham, as for Austin and other positivists, the law's voice is the peremptory voice of a sovereign's commands backed by threats. We hear that voice ourselves as subjects whose task is to obey or to disobey and face the consequences. That's one picture of law, law as commands backed by threats, commands issued by a sovereign to a populace who are subject to the sovereign. And that is just how criminal law appears to many of those who face its coercive attentions. To many who appear in our courts, to many who are in our prisons, the law's voice is the voice of an alien sovereign issuing commands, orders, backed by threats of sanctions, sanctions which are then imposed. So Bentham is right about how law in fact appears, how law in fact is heard by many of those subject to it. But is it how law should be heard? Is it how law should address us as citizens of what we hope is a liberal democracy? And surely the answer is no. We shouldn't hear the law in those tones, as the tones of a peremptory sovereign issuing commands to us. It's true, of course, I guess for many of us, certainly for me, that in some cases I obey the law because I fear the sanctions. I obey the speed limit not from respect for other road users, but because there's a speed camera. I pay my taxis because there's a tax inspector and I might get caught. So for many of us, perhaps too many, too much of the time, the law's voice is the voice of sanction-backed requirements. Do this or else. But even then, for most of us, we hope, that's not the only voice the law speaks in. I don't just hear the peremptory command, do this or else. I also hear in the background, addressing my better nature, the law's moral voice. Do this because you owe this to your fellows to drive safely. Pay taxes because that's your contribution towards the common good. So even when we obey the law in fact through fear of sanctions, we still hope we can hear, in our better moments, the moral voice behind those sanctions. Whereas Bentham's law just says, do this or else. It's just the sovereign commanding us. There's something missing from the sovereign's command model. But more importantly, if you ask what it is to be a member of a liberal democracy, to be a citizen, surely the law should not be an alien law imposed on you by a sovereign. The law should be our law as citizens. And what I want to sketch now is the ideal of law as a law which is our law, not a law imposed on us, but a law which is ours as members of the polity. This is the ideal of the common law. The common law ideal is the ideal of the law as the law of the community whose law it is. A law not imposed by a sovereign, but a law which emerges from the community and its own deliberations. A law to which we subject ourselves. It's not imposed on us by a sovereign, but we ourselves are makers of law. We live under the law and with the law. In that sense, it's our law, which we make for ourselves and impose on ourselves and on each other. And that's why I say it's a law for citizens, a law for members of a polity whose own polity it is and thus whose own law it is. Bentham's law speaks to us in the voice of the sovereign. The sovereign says, do this or else. A civic law, a law for citizens, speaks to us in our own voice. It speaks to us of our own values that we share as citizens, the values that define our lives together in a polity. That's the ideal of law for a liberal democracy, a law which is our law speaking in our voice. I'll say more later what the law says to us, but the voice of the law, ideally, is our own voice, which we hear as citizens speaking to ourselves and each other. If that's what law in general should be, if law should be law for citizens, which they make for and create for themselves and live under as citizens, we have to ask what kind of criminal law is apt for citizens. Of course, there is more to be said than I can say here about what it is to be a citizen. The whole books are written about citizenship and what it means in a liberal democracy. However, a slogan, though, to be a citizen is to be a full member of the political community. And we can use as our slogan in this context, Dworkin's idea of equal concern and respect. As citizens, we owe each other concern and respect as fellow members of the polity. The notion of equality is central. We're all equally members. We all recognise ourselves as fellows in that sense. And we owe ourselves both respect and concern as citizens. So that's a gesture towards what it is to be a citizen. And the question is, if that's how we see ourselves and each other, if we see ourselves as fellow members engaged together in the enterprise of living together as a polity, what kind of criminal law could be appropriate for those kinds of being? What kind of criminal law could be consistent with or could express that regard to each other as citizens, which is important? How can we treat each other with respect and concern under the aegis of criminal law? That's the question we face. If we try to make sense of criminal law in a modern democracy, what kind of criminal law can express that regard for each other as citizens, as fellow members of the polity? There are two questions I should, among others, I'll note and leave aside for the time being, which are very important. The first is about the conditions or criteria of citizenship. If law is law for citizens, then how do you get to be a citizen? By birth, by entry, what are the criteria, what are the qualifications, what conditions are there for citizenship? That's one important issue. Secondly, within any modern polity, you have citizens who are there as members, and also various kinds of non-citizen. Those who are there as temporary guests, or visitors, or workers, or immigrants, or refugees. We have to ask not just how the law treats citizens, but how the law will treat non-citizens who are there temporarily. And that's an important issue which I can't address here, but I note in passing that a focus of law as law for citizens, which is my focus here, raises these further two questions about citizenship and those who are not citizens, which will need to be addressed in any full account of criminal law, but not here, not now. So start off then with what kind of content the criminal law will have as a law for citizens. One important point is that the law, from this point of view, does not consist in prohibitions. Bentham's law is a law of prohibitions. The law says, do this, don't do that. The law prohibits conduct. Prohibitions offer us new reasons for action. Don't do that because you're told not to. Don't do that because the law says don't do it. That's prohibitions. They give you new reasons for action. You don't do it because you respect the law or you fear the punishment. But that's not what the criminal law says to us as citizens. When the law defines murder, or rape, or theft, or assault as offences, as crimes. It's not prohibiting these actions, as if we need new reasons not to do them. The law doesn't say, don't commit murder because it's against the law. Don't commit theft because it's against the law. And if you're a citizen, you don't refrain from these crimes because they're against the law. And what kind of person would it be? You say, well, of course, I would murder people, but it's illegal, so I won't. I would commit theft, but I respect the law, so I won't. That's not a coherent kind of normative stance. We refrain from murder and rape and theft, not because the law tells us to, but because we know full well they are already pre-legally wrong. So the law doesn't prohibit these actions. It doesn't say, here's a new reason not to do them, that the law prohibits it. At least our own law doesn't. What the law rather does is say, look, here are certain kinds of wrong, pre-existing wrong, which are, in an important sense, public wrongs. They're wrongs which concern us all as citizens. Some wrongs are private. If I let down a friend, or betray my wife's confidence, or I'm unfaithful, that's a matter between me and my friend, between me and my wife. That doesn't concern the rest of us. That's private. Other matters, other wrongs are public. Other wrongs concern all of us as citizens. And those are the wrongs that we criminalise. Wrongs that are public, i.e. that are our business collectively as citizens. And the initial function of criminal law is to define that range of public wrongs. It says these are the wrongs which we as a polity take seriously as public matters. There are at least two kinds of criminal wrong. The first I mentioned, the obvious ones, which wrongs like the central crimes, murder, other kinds of attack on the person, rape and theft and so on, these are wrongs which are entirely pre-legal. You don't need the law for these wrongs to exist as wrongs, to be recognised as wrongs. That's the simple case of wrongs that the law presupposes as wrongs and defines as public wrongs. But then there are also a whole range of wrongs, the so-called mala prohibita. Conduct that's wrong only because the law prohibits it. The law says, don't drive more than 70 miles an hour on this road. Absent the law, that's not wrong. But when the law says that's the speed limit, then I have a duty to obey that limit. The law says, pay this much of your salary in taxation. Before the law required that of me, I had no such duty. So these wrongs are, in a sense, legal wrongs. They are wrongs because the law requires certain kinds of conduct of me. But still, the crucial point, though, is that even in these cases, they're not wrong because they're criminal. You've got the tax law. The tax law defines how we should contribute to the common good by paying a certain portion of our income. The driving laws regulate how we should drive. These are all pre-criminal regulations, which lay down patterns of conduct which are appropriate because, in some important way, they serve the common good. Once you have those regulations in place, once you've got a set of taxation laws or driving laws, which are themselves just and fair, it then is a moral wrong to break them. Because if you break those laws, you're failing in your civic duty. You're failing to show the respect you owe your fellow citizens and the regulations which govern your life. So even in these cases, these are made criminal wrongs because they're a kind of wrong which should concern all of us as citizens. So the general claim so far is that the criminal law does not create wrongs. It doesn't make wrong what wasn't wrong before. The criminal law presupposes a range of wrongs. Wrongs either of a pre-legal kind or wrongs which involve the breach of a justified legal regulation. And the criminal law says these wrongs are public matters. These wrongs concern all of us as citizens. These wrongs we must take note of as citizens because they're public wrongs. And that's the first task of criminal law, is to define that set of public wrongs. And of course, one key issue, which again I can't address here, is, okay, which wrongs should be public? How do we decide, as a polity, which wrongs will come into the public sphere or which wrongs come into the private? And we're all familiar with debates about this kind of issue, which wrongs fall in which kind of sphere. But one task of criminal law is to define that range of public wrongs. But that's a prelude to what in a way is the most important aspect of criminal law. The law says these are public wrongs, meaning by that these are wrongs we must take note of as citizens. So what note do we take? The note we take of them is given by the criminal process. The criminal process of trial, and of course in the end punishment, is the way in which, as a polity, we take formal notice of public wrongs. So we need to look at the role the criminal trial plays in a liberal system of criminal law. Now, in some views, many theories take the view, the trial is not in itself an important issue. The trial has a purely instrumental role. You need to find out who to punish. You need to know how to focus punishment on those who deserve it. And the trial, in this view, is the way in which we find out who gets punished. The trial connects crime to punishment by picking out those who committed the crime who thus get punished. On that view, the trial itself is purely a technique for getting from crime to punishment. Nothing more to it than that. But that seems inadequate as a view, a kind of what the trial is about in a modern legal system. It can't do justice to essential features of our trial process. And here are three such features. First of all, it matters that the defendant is, as they say, fit to be tried. Imagine a person who committed a crime 6 months ago, a year ago. They committed the murder or the rape. And you could prove their guilt with the evidence you've got. But since the crime, they've become so mentally disordered that they can't understand what's going on in court. They can sit there, but they just don't know what on earth is going on. They're unable to grasp the trial. That person is not fit to be tried. You can't try them in law. And that seems right. To put a person on trial in a public court who can't understand the process, that seems grotesque. And not because you can't prove their guilt, perhaps you can. So if the trial is just to find out who's guilty, then you could try them. But there's something amiss about trying a person who can't even understand it. Second feature, it matters in the trial process that the defendant enters a plea. The defendant pleads guilty or not guilty. Okay, they aren't now forced to. They used to be forced to. They used to be, in effect, punished if they wouldn't plead. But now it all matters that they enter a plea of guilty or not guilty. Okay, why should that matter if the only point of the trial is to find out who gets punished? And so the verdict itself isn't just a kind of finding of fact, yes, he did it. The verdict constitutes a public declaration of guilt. The plea in the first place, you plead guilty or not guilty. If you plead guilty, you say, yes, I confess my guilt. Or not guilty, you challenge the prosecution to prove it. Conviction declares your guilt publicly as a condemnation. So there is far more to the trial than just a matter of finding out who did what or who gets punished. What more there is, it seems to me, is a process of calling to account. The trial is the forum in which we are called to account by our fellows, through the court, to answer charges of wrongdoing. So the defendant is there, centre stage, not as a person upon whom judgment is to be passed, as a person who is called to answer for himself for his own actions. And that's why it matters that the defendant is fit to plead, can understand the trial, because he's there to answer the charge. He must then understand the charge if he's to have a chance to answer it. And we get here to the central part played in criminal law by the notion of responsibility as answerability. To be a member of a community of any kind is to be, among other things, answerable to your fellows for your conduct as a member. To be a member of a department is to answer to your colleagues for the way you conduct yourself in the department. So membership of the community brings with it responsibility for your conduct to your fellows. And so as a citizen, I'm answerable to my fellow citizens, not for my entire life. Of course, much of my life is still private. I don't answer to all of you as citizens for my private life, for my friendships, my dealings with my wife, my children. That's not your business. But I do answer to you as citizens for my conduct in the public realm, my conduct in our civic life. And crucially, I answer to you as citizens for my commission of any public wrongs. If I commit murder or theft or fraud or dangerous driving, I answer not to the sovereign, not to the police, but to you, my fellow citizens, whose values I violated, whose laws I have broken. And the trial is the forum in which this happens. There are two kinds of answering. First of all, if I'm charged with a criminal offence, I'm summoned to court to answer the charge. I'm asked to enter a plea. Do you plead guilty or not guilty? I might plead guilty, thus confessing, yes, I am guilty. Not just, in fact, I did it. Guilty is a confession of guilt, not just a neutral statement. Or I plead not guilty, in fact, challenge you to prove it. In answering to the charge, I thus recognise that I must answer to you for what I've done. It is your business. And answer to the court, and through the court, I answer to all of you. then the trial starts. Suppose the prosecution proves their case. They prove that, indeed, I did commit the offence. They prove that I wounded someone intentionally, or that I destroyed their property. I must now answer for that offence, for that wrong I've committed. I must answer for wounding you or damaging your property. I might have a good answer. I say, look, yes, I got a defence. Yes, I wounded them, but in self-defence. Yes, I destroyed your property, but I had to do it, necessity. So I might have an answer to offer which acquits me of blame. I did the crime, but I had a justification or excuse. Or perhaps I have no answer. Perhaps I've got nothing I can say to exculpate myself. I'm then convicted. But still, I must answer now for what I've done, either by giving a defence or by accepting condemnation as a wrongdoer. So the trial calls me to answer to the charge and to answer for my conduct if it's proved that I did the crime. And that's why the trial is far more than mere findings of fact. The trial is the forum in which, the public forum in which we are called to account by our fellows, to our fellows, for our alleged wrongdoing. Why does that matter? Why should we have this kind of formal process of calling to account? It's because that's the way in which we take our values and ourselves and each other seriously as members of a polity. For a start, don't forget that the criminal law aspires at least to represent our own shared public values, the values which define our lives together as citizens. If we care about those values as citizens, we must care about their violation. We can't just ignore violations as if they didn't matter, because they do matter. We need to find some way of showing how we take those things seriously, and the trial helps us do that. More precisely, we owe it to the victims of crime, when there are victims, to take their wrongdoing seriously. Because victims of crime haven't just been harmed. If a person has been mugged, they might have suffered physical harm, material loss, but also they've been wronged. They've been attacked by a fellow. So insofar as crimes involve wrongs, we must take those wrongs seriously. We recognise the wrong suffered and address it appropriately. And the way to address a wrong is, or an obvious way, is to try to find the perpetrator and call them to account. I recognise the wrong you suffered. I take it seriously by trying to bring to account the person who wronged you. If you ask me, what do victims demand very often, is precisely that, an accounting from their wrongdoer. They want to see the person brought to account for what they've done. So criminal law takes victims' wrongs seriously as wrongs, not as harms, but as wrongs. We call to account those who commit such wrongs. But also, even more crucially, we owe this to the offenders themselves as our fellow citizens. Because don't forget, we are fellows not just to victims, but also to offenders. We're all citizens in this together. The offender who breaks the law, the offender who commits the crime, is our fellow. And we also, how do we take each other seriously as wrongdoers? Not by ignoring the wrong as if it didn't matter, not by passing it off as something unimportant, not by diagnosing it as some kind of illness. We treat the person as a responsible agent, as it is someone who must answer for what they have done. So being held to be answerable is to be treated as a serious, responsible member of the community. So the trial, as a calling to account, does justice both to victims and also to offenders who are treated as responsible agents who are to answer for what they have done. And that's why trials matter as this kind of process. So if we see ourselves as fellow members of a moral community, of a polity, as citizens of a republic, we must treat ourselves with the kind of respect which that status brings with it, demands. And that includes, among many other things, calling each other to answer for the wrongs we commit when they're public wrongs. And that's the point of the criminal trial. And that's why the criminal trial is central to a republican criminal law. It's a forum in which we are held to account as responsible citizens. Of course, trials aren't the end of the matter. There's the trial, conviction, and the conviction itself is a condemnation of the wrongdoer. It's not a finding of fact. You're condemned as a wrongdoer. But then, of course, post-conviction comes punishment. You get the fine, imprisonment, or whatever it is the sentence might be. And the challenge now, which again I just need to note and wave at in passing, is how can punishment be consistent with citizenship? Because think of how punishment operates. Think of imprisonment. You're sentenced to 10 years in jail. You're put away from the community. You're locked away behind the walls that symbolize your exclusion. Punishment, as it operates, is often received, heard, understood, seen as exclusionary. You're pushed out from citizenship into the prison. So how can citizens punish each other as citizens? There's a real challenge here for any kind of liberal political theory, how punishment can be consistent with the respect we owe each other as citizens. If the point, remember, the trial is a way of recognizing the other as a fellow citizen. We call the person to account not as an alien or an enemy, but as a fellow who has done wrong. The trial as a process of calling to account does respect the offender as a citizen. How can punishment do that? How can imprisonment also express that kind of regard for the other as a citizen? That's the challenge. Or can we find modes of punishment which do indeed express that regard for the other as a citizen? I think, I don't know what happens in Australia, I meant to check this. Certainly in Britain, if you're imprisoned as a felon for a felony, you lose the right to vote while you're imprisoned. In America, in some states, if you're imprisoned as a felon, you lose the right to vote for life. That is a dramatic kind of expression of exclusion from citizenship. You're put away from your fellows and you're excluded from the political process, which is central to citizenship. So that punishment of that kind, punishment which involves the loss of the right to vote, the right to take part in civic life, that punishment does not treat you as a citizen. That punishment excludes you from citizenship. Can we avoid that? Can we have punishment which doesn't in that way exclude the person punished from fellowship? And some would say that we don't need to look for that. On some views, certainly some theorists take this view, and if you listen to politicians, they clearly believe this. Those who commit crimes thereby forfeit their own civic standing. If you break the law, if you commit the crime, then you cease to be a citizen. And of course, you can be punished as something other, as an enemy, as an outsider, as a dangerous person we need protection against. That's one view that is all too common. And it can't be a view of, actually a serious view of all offenders. No one can believe that anyone who commits any crime thereby ceases to be a citizen. Anyone who breaks the speed limit, anyone who pays their tax, anyone who commits minor theft, of course, no one can believe that. What they believe is that those who commit certain kinds of crime, the crimes that are serious, the crimes that we, of course, don't commit, the crimes of the other, those people are, by breaking the law, forfeiting their civic standing. And that's an all too prevalent view. It's also surely a view we should resist. If we're serious about citizenship, if we're serious about membership of a normative community, if we're serious about seeing each other as citizens, we'll see each other as citizens even when, perhaps especially when, we do commit serious wrongs. That's what fellowship involves. It can't be that easy to cease to be a fellow. Just one crime can't exclude you from the fellowship. There are certain versions of contractual theory which are the social contract, and that does invite the idea of exclusion. If you break the contract, then of course you're out. But if you see membership as a polity as more than contractual, you see it as a kind of fellowship which involves recognizing the other as your fellow in a civic life. We shouldn't make it so easy to lose your standing. We must find ways of treating others, however serious their wrongdoing, still as our fellow citizens. And the question is, how can punishment do that? Again, there's a real question, which again I have to wave at in passing, about whether that's always true. Or one might say, look, think of the really persistent, serious career criminal. The person who devotes their life to exploiting others, to violating others' rights, must we still say that whatever they've done, they remain our fellow? Or does there come a point where the crimes are serious enough, persistent enough, gross enough as violations of our shared values? We can no longer see that person as a fellow. There is a question there to be answered, which I can't answer here. But it does seem to me, this is a normative, not a conceptual claim, that for the vast majority of offenders and offences, we cannot, honestly, simply say, well, once you quitted the crime, you cease to be a citizen. We say the crime you committed is one we must address as a serious wrong. We address it to you as still our fellow. And if we believe that, the question is, well, how then can we punish you? What punishments are consistent with that perspective on the offender?